In Penal Code Section 415, one of the ways that you can be charged with disturbing the peace is by fighting in public, or what prosecutors and justice officials often call mutual combat. So that's a situation where you're not merely defending yourself, but you really want to be fighting. You're really engaged in this fight.
Another example of disturbing the peace is by being loud and unreasonable in a willful and malicious manner. Liability for this crime typically depends on the context. For example, if you have a large party in the middle of the day that tends to have loud music, you're likely not liable for the crime of disturbing the peace. However, if after an argument with your neighbor, you turn on all of your outdoor speakers very loudly and point them in the direction of your neighbor, then you're likely going to be liable for disturbing the peace.
Another way you can be charged with disturbing the peace is through the use of fighting words. Now, fighting words are words or phrases that are so offensive and so inflammatory that they're very likely to produce a violent response. Now, normally limitations on free speech generally trigger First Amendment issues, and the Supreme Court has been very deliberate and very narrow in the kinds of speech that they'll limit. However, words or phrases that are so likely to produce a violent response are under this limitation of the First Amendment. For example, say you have a family member arrested outside of your home, and you approach the police officer and you start yelling racial slurs at him, and you challenge him to a fist fight. Now, in this particular scenario, those fighting words could lead to a disturbing the peace charge because what you were saying was so inflammatory and so offensive that you were very likely to receive a violent response. Therefore, this kind of language would not be covered under your First Amendment freedom of speech protection.
Disturbing the peace under Penal Code Section 415 is a misdemeanor. If you're convicted, you could face probation, fines, and potentially up to 90 days in jail. But most of all, it's a crime. It's not just an infraction. So if you are convicted, it will give you a criminal record that potentially will show up on background checks when you apply for employment or other benefits.
The legal definition of disturbing the peace is somewhat vague. Therefore, it's very difficult for prosecutors to prove. Fortunately, that means that it's easy for criminal defense attorneys to defend against. This is why it is critical to discuss your case now with a criminal defense attorney who can help you avoid conviction.
An experienced criminal defense attorney will often use disturbing the peace as a bargaining tool to reduce a higher offense. Now, for example, say a person is charged with a prostitution offense. And prostitution is a charge that comes with negative social connotations, higher penalties, and it's also a crime of moral turpitude. But oftentimes, we're able to negotiate it down to a disturbing the peace, which is a much more lower level innocuous offense. And oftentimes, we're even able to negotiate it to disturbing the peace as an infraction, which will then result in no criminal record whatsoever.